Hello! Welcome to the Study With Me series of Law School Buddy. I have prepared audiobook materials following the syllabus of the Philippine bar exams dedicated to our law school students. I hope that this audiobook can help with your study and review. Let's begin. This episode will cover Chapter 7, Extinguishment of Sale. Article 1600. Sales are extinguished by the same causes as all other obligations, by those stated in the preceding articles of this title, and by conventional or illegal redemption. Section 1. Conventional redemption. Article 1601. Conventional redemption shall take place when the vendor reserves the right to repurchase the things sold, with the obligation to comply with the provisions of Article 1616 and other stipulations which may have been agreed upon. Article 1602. The contract shall be presumed to be an equitable mortgage in any of the following cases. 1. When the price of a sale, with right to repurchase, is unusually inadequate. 2. When a vendor remains in possession as lessee, or otherwise. 3. When upon or after the expiration of the right to repurchase, another instrument extending the period of redemption, or granting a new period, is executed. 4. When the purchaser retains for himself a part of the purchase price. 5. When the vendor binds himself to pay the taxes on the things sold. 6. In any other case, where it may be fairly inferred that the real intention of the parties is that the transaction shall secure the payment of a debt or the performance of any other obligation. In any of the foregoing cases, any money, fruits, or other benefit to be received by the vendee as rent or otherwise, shall be considered as interest, which shall be subject to the usury laws. Article 1603. In case of doubt, a contract purporting to be a sale, with right to repurchase, shall be construed as an equitable mortgage. Article 1604. The provisions of Article 1602 shall also apply to a contract purporting to be an absolute sale. Article 1605. In the cases referred to in Article 1602 and 1604, the apparent vendor may ask for the reformation of the instrument. Article 1606. The right referred to in Article 1601, in the absence of an express agreement, shall last 4 years from the date of the contract. Should there be an agreement, the period cannot exceed 10 years. However, the vendor may still exercise the right to repurchase within 30 days from the time final judgment was rendered in a civil actio, and on the basis that the contract was a true sale, with right to repurchase. Article 1607. In case of real property, the consolidation of ownership in the vendee, by virtue of the failure of the vendor to comply with the provisions of Article 1616, shall not be recorded in the Registry of Property without a judicial order, after the vendor has been duly heard. Article 1608. The vendor may bring his action against every possessor whose right is derived from the vendee, even if in the second contract no mention should have been made of the right to repurchase, without prejudice to the provisions of the mortgage law and the land registration law with respect to third persons. Article 1609. The vendee is subrogated to the vendor's rights and actions. Article 1610. The creditors of the vendor cannot make use of the right of redemption against the vendee until after they have exhausted the property of the vendor. Article 1611. In a sale with a right to repurchase, the vendee of a part of an undivided immovable, who acquires the whole thereof, in the case of Article 498, may compel the vendor to redeem the whole property, if the latter wishes to make use of the right of redemption. Article 1612. If several persons, jointly and in the same contract, should sell an undivided immovable, with a right of repurchase, none of them may exercise this right for more than his respective share. The same rule shall apply if the person who sold an immovable alone has left several heirs, in which case each of the latter may only redeem the part which he may have acquired. Article 1613. In the case of the preceding article, the vendee may demand of all the vendors or co-heirs that they come to an agreement upon the repurchase of the whole thing sold, and should they fail to do so, the vendee cannot be compelled to consent to a partial redemption. Article 1614. Each one of the co-owners of an undivided immovable, who may have sold his shares separately, may independently exercise the right of repurchase, as regards his own share, and the vendee cannot compel him to redeem the whole property. Article 1615. If the vendee should leave several heirs, the action for redemption cannot be brought against each of them, except for his own share, whether the thing be undivided, or it has been partitioned among them. But if the inheritance has been divided, and the thing sold has been awarded to one of the heirs, the action for redemption may be instituted against him for the whole. Article 1616. The vendor cannot avail himself of the right of repurchase, without returning to the vendee the price of the sale, and in addition, 1. The expenses of the contract, and any other legitimate payments made by reason of the sale. 2. The necessary and useful expenses made on the thing sold. Article 1617. If at the time of the execution of the sale, there should be on the land, visible or growing fruits, there shall be no reimbursement for, or prorating of those existing at the time of redemption, if no indemnity was paid by the purchaser when the sale was executed. Should there have been no fruits at the time of the sale, and some exist at the time of redemption, they shall be prorated between the redemptioner and the vendee, giving the latter the part corresponding to the time he possessed the land in the last year, counted from the anniversary of the date of the sale. Article 1618. The vendor who recovers the thing sold shall receive it free from all charges or mortgages constituted by the vendee, but he shall respect the leases, which the latter may have executed in good faith, and in accordance with the custom of the place where the land is situated. Section 2. Legal redemption. Article 1619. Legal redemption is the right to be subrogated, upon the same terms and conditions stipulated in the contract, in the place of one who acquires a thing, by purchase or dation in payment, or by any other transaction, whereby ownership is transmitted by owner's title. Article 1620. A co-owner of a thing may exercise the right of redemption in case the shares of all the other co-owners, or of any of them, are sold to a third person. If the price of the alienation is grossly excessive, the redemptioner shall pay only a reasonable one. Should two or more co-owners desire to exercise the right of redemption, they may only do so in proportion to the share they may respectively have in the thing owned in common. Article 1621. The owners of adjoining lands shall also have the right of redemption when a piece of rural land, the area of which does not exceed 1 hectare, is alienated, unless the grantee does not own any rural land. This right is not applicable to adjacent lands, which are separated by brooks, drains, ravines, roads, and other apparent servitudes, for the benefit of other estates. If two or more adjoining owners desire to exercise the right of redemption at the same time, the owner of the adjoining land of smaller area shall be preferred, and should both lands have the same area, the one who first requested the redemption. Article 1622. Whenever a piece of urban land, which is so small and so situated that a major portion thereof cannot be used for any practical purpose within a reasonable time, having been bought merely for speculation, is about to be resold, the owner of any adjoining land has a right of preemption at a reasonable price. If the resale has been perfected, the owner of the adjoining land shall have a right of redemption, also at a reasonable price. When two or more owners of adjoining lands wish to exercise the right of preemption or redemption, the owner whose intended use of the land in question appears best justified shall be preferred. Article 1623. The right of legal preemption or redemption shall not be exercised except within 30 days from the notice in writing by the prospective vendor, or by the vendor, as the case may be. The deed of sale shall not be recorded in the registry of property unless accompanied by an affidavit of the vendor that he has given written notice thereof to all possible redemptioners. The right of redemption of co-owners excludes that of adjoining owners. And that is the end. If this audiobook has helped you, please comment down below and like and share our video to someone who might need it. Thank you so much for making us your law school buddy.